Good morning. We got great news for you, friends. Great news for certain migrants. Okay, the Supreme Court of the United States has set a precedent in Santos Zacaria versus Garland. We know that Garland is the Attorney General. So, in conclusion, this case was remanded back for further adjudication. So, we're going to talk about it and how we can use this case moving forward. Okay, to actually help you review decisions of the Immigration Board of Appeals in circuit courts. Okay, so again, my name is Bijoux Ngwanda, as you know it. I'm an immigration lawyer based here in DC. However, I do work with individuals across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, you know what to do. Please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also, follow me on all platforms. We have TikTok, Instagram, Facebook page, and Facebook group. Today, 3 p.m. Eastern time, please bring all your questions, okay? We're going to take 1 hour in celebration of Mother's Day. We're going to answer your questions about your children, how they can help you, okay? Get either lawful status or protection. But let me just get into the story. This is great news. You can see me smiling because this is a story of perseverance, my friend. When it comes to immigration, some people give up earlier. I always tell my clients, it's just the beginning. If you have the energy, the patience, the endurance, we can persevere and eventually we'll get to a solution, right? At that point, you will say that I've tried everything that I could possibly, humanly possible to try. Then you have some type of peace too, because you've tried everything. So let's get right into it. Let me share my screen. We're going to learn about Santos Zacaria, okay, and how she has set precedent for all of us. Let's get right into it. Let me share the screen. We're gonna learn it. You really listen carefully to this story because we're really gonna learn something here today, and hopefully it's gonna help some people. Okay, so this is the story, right? We have the Supreme Court of the United States on writ of certiorari to the United States Court of Appeals for the Fifth Circuit. Okay, and that decision came on May 11, 2023, this week. Okay, so Justice Jackson delivered the opinion of the court. What's going on is this, right? Under U.S. Code 8, paragraph 1252D1, a non-citizen who seeks to challenge an order of removal in court must first exhaust certain administrative remedies. They're talking about federal court, like circuit court. If you don't agree with the Board of Immigration, the law says that you must first exhaust certain administrative remedies before going straight to the Fifth Circuit. Okay, even if you don't agree with the immigration judge, you must first exhaust certain administrative remedies before going straight to the court, the circuit court. Well, that's what's going on in this case. However, what they said the decision was that the case presented two questions regarding the statutory provision. For the reason explained below, we're going to go into it. The court hold that the paragraph 1252D1 is not jurisdictional, and further hold that a non-citizen need not request discretionary forms of administrative review like reconsideration of an unfavorable Board of Immigration Appeals determination in order to satisfy paragraph 1252 D1 exhaustion requirement. So that's the holding, okay? That's what they held on May 11, 2023. But let's study the story, then you understand really what's going on. Okay. So the petitioner by the name of Santos Zacaria, Leon Santos Zacaria, who goes by the name Estrella, fled her native Guatemala in her early teens. She fled her country because she has testified that she left that country and fears returning because she suffered physical harm and faced death threats as a transgender woman who is attracted to men. Okay, she's a transgender woman attracted to men, and she was persecuted in the past in Guatemala. That's why she fled the country. Okay, so eventually she came here in the United States. However, her first stay in the country was brief, right? And she was removed by immigration authorities in 2008. While she came, applied for asylum, it didn't work out. She was ordered removed, and she was physically removed by authorities in 2008. Then she re-entered in 2018. You see, 10 years later. Because why? Because of the ban, right? If you have the order of removal, technically you're banned for 10 years. Some people try to re-enter illegally, but if you want to try to re-enter again in due course, really 10 years has to lapse, okay? Unless you have some other ways of waivers and stuff like that. But anyway, she waited for 10 years. Then she was apprehended again by immigration authorities. At that point, she sought protection from removal, including withholding of removal, based on the likelihood she would be persecuted in Guatemala. While she got apprehended, I believe she was crossing the border, she got apprehended again, and then she sought protection, right? And including withholding of removal. However, what happened was the immigration judge went ahead and reinstated the same prior order of removal and denying her the protection she sought. They just went with the same order of removal. They reinstated that, and they denied her the protection she sought while she went on appeal. On appeal, the immigration judge on appeal pretty much upheld the decision of the immigration judge. So they on appeal, they maintained the same decision of the immigration judge, pretty much ordering her removed again. Well, although the board agreed with Santos Zacaria in part, they agreed with her in part, determining that she had suffered past persecution in Guatemala and was therefore entitled to the presumption of future persecution. Okay? They agree with her. They say, yes, of course you have suffered past persecution. You are therefore entitled to the presumption of future persecution. Remember, in court, if you can, when it comes to asylum, really, if you can show that you've faced persecution in the past, the presumption of future persecution, you're already entitled to it. Therefore, most likely they have to grant you withholding of removal, even though they don't grant you asylum, right? Because in asylum context, even when you cannot actually show that you suffer past persecution, you, however, can also show that you can suffer future persecution. And we've talked about it already before, as far as how you show that you will suffer future persecution. So they agree with her. They say, yes, you have suffered past persecution, and yes, you were entitled to the future, to the presumption of future persecution. However, it was already rebutted in immigration court. So basically, they're trying to tell her that, well, the presumption or the entitlement of the presumption of future persecution was rebutted in immigration court. So in immigration court, they they provided a rebuttal. So pretty much they already did what they're supposed to do. You know, when you say, well, I will face a future persecution, then the government has the burden of proof to rebuttal your argument. So this is what the Board of Appeal is saying, like, well, however, it was rebutted in court. So, which was an issue that the immigration judge has not reached. It was rebutted in court, but the immigration judge did not elaborate on it. Well, then Zacaria did not. In other words, they maintained the same decision, but in the reasoning, they maintained the decision of the immigration judge. But in their reasoning, they're telling her, yes, of course, we agree with you. You suffer past persecution. However, while it was already rebutted in court, even though the immigration judge did not elaborate on that issue, but we can see here that the rebuttal was offered in court, in the immigration court. So Santos Zacaria then filed a petition for review, okay, at the U.S. Court of Appeal for the Fifth Circuit under Title 8 U.S. Code, okay, paragraph 1252. Among other things, she said that when the board concluded that the presumption of future persecution was rebutted, it had impermissibly engaged in fact-finding that only the immigration judge could perform. So now they go to Fifth Circuit. In order to go to Fifth Circuit to review the decision, you got to have a reason, right? So one, among other things, their reason was, well, why the board should engage in fact-finding. That's something that only the immigration judge is supposed to do. Okay, why the judge, why the Board of Appeal will say something like this? That's not permissible for them to say it. Well, unfortunately for them, the Fifth Circuit said that, well, you should have gone back to the Board of Appeal, Immigration Board of Appeal, and tell them to reconsider the decision. Okay, then they pretty much dismiss her case. Okay, because they said that you have not exhausted all administrative remedies. So even though you said that the Immigration Board of Appeals made a mistake, acted without permission to engage in fact-finding, that's the only job for the immigration judge at the immigration court. While you are right, but you should have gone back to them to reconsider their decision. Oh, Zacaria couldn't take it. She couldn't take it. She went all the way to the Supreme Court, and the Supreme Court said that no, she can't go back to the same people who gave her the actual not favorable decision for them to reconsider, to review their own decision. It's not going to work like that. Okay? So, and then so really that's what happened here on the Fifth Circuit. Well, and then the Fifth Circuit said we lack jurisdiction on the ground that she failed to exhaust administrative remedies. Further, the court held that because Santos had not raised the impermissible fact-finding challenge in a motion to reconsider, that's just what I said. We cannot, we're just dismissing this case basically because she hasn't satisfied the exhaustion requirement. Well, the Supreme Court of the United States said that no, she did. She started with immigration court. She didn't agree with the immigration court decision. She went at the Immigration Board of Appeal, and the Immigration Board of Appeal, in the reasoning, even made a mistake and started trying to do some type of fine-facting determination. That's why she went to the Fifth Circuit, for the Fifth Circuit to review that. And then the Fifth Circuit telling her that you need to go back to them to reconsider their decision prior to coming to us because you haven't exhausted all the requirements, all the administrative remedy. The Supreme Court said, no, she did all that. She can't go back to the same people who actually gave her if a not favorable decision, for them to review or reconsider their decision. She's not going to come up with something pretty much substantial. So that's why they granted secretariat to resolve this conflict. So there is a disagreement among the Court of Appeal concerning two issues presented: whether exhaustion requirement is jurisdictional and whether require seeking discretionary and administrative review like reconsideration by the Board of Immigration Appeal. So basically, if you want to know it, it's here really where they say that it's not jurisdictional. You see, when we say here, they say, well, it is not jurisdictional. It's some type of discretionary measure, motion to reconsider. Therefore, this person cannot go back to the same people. Wow, this is a great, let me stop sharing. This is a great precedent for us, meaning that if you have a decision for an immigration judge, you did not agree with it, you go to the Board of Appeal and you don't agree with them, their decision, you can go straight to the Fifth Circuit Court. You don't have to file another motion to reconsider in between that Board of Immigration Appeal decision and the Fifth Circuit Court. You cannot, because you at that point you already exhausted all administrative remedies. So that the issue, and that has been settled once and for all. My friend, we are going to have a live session today, 3 p.m. Eastern time, and I'll be answering questions. We got it 1 hour, the entire hour, to answer questions. Please bring your questions, because some people will be like, when we have live sessions, they don't show up and then they send you a paragraph. No, my friend, if you want a free question and answer it, just come to our live sessions, okay? So again, we take cases across the country and around the world, because complex immigration issues is our forte. And if we cannot do it, we'll refer you to somebody who has more experience than us. As a matter of fact, we have referred 2 people already to some other lawyers who has more experience in that particular area. So always try to consult with a qualifying lawyer so that you can get your case resolved. Okay, happy Mother's Day weekend, my friend. We are here. It's so great for this decision, and I'm so happy to meet you again today, 3 p.m. Eastern time, in celebration of Mother's Day. Okay, until next time, bye-bye.